Good day, everyone. I'm Christian John Laysa. I'll be reporting to you the Article 1380, 1385, 1391, and 1396. Article 1380 states that contracts validly agreed upon may be rescinded in the cases established by law. For the interpretation, a cessible contract is one that was entered into legally by the contracting parties but resulted in economic damage to one of the parties of an outside party. The court can therefore rescind or set aside a contract for equitable reasons. Under the article, the contracts are rescissible if their defect consists in injury or damage either to one of the contracting parties or to third persons. Number 2. Person rescission, they are valid and therefore legally effective. For number 3, they can be attacked directly only and not collaterally. In fourth, they can be attacked only either by a contracting party or by a third person who is injured or defrauded. The last one is, they are susceptible of convalidation only by prescription and not by ratification. And now we will be moving for the Article 1380 example. The situation concludes that Kara sues Mia for the recovery of a parcel of land. In this case, the land is a thing under litigation. If, during the pendency of the case, Mia sells the land to a third party without the approval of Kara or of the court. Now, the question is the sale rescissible? The answer is yes. The sale is rescissible at the instance of Kara in case she wins in her suit for the recovery of said land, unless the third party is in legal possession of the land in good faith. Going for the next article, Article 1385. In the Article 1385 states that rescission creates the obligation to return the things which were the object of the contract, together with their fruits and the price with its interest. Consequently, it can be carried out only when he who demands rescission can return whatever he may be obliged to restore. Neither shall rescission take place when the things which are the object of the contract are legally in the possession of third persons who did not act in bad faith. In this case, indemnity for damages may be demanded from the person causing the loss. For the interpretation, this article provides mutual restitution where there is a delivery on both sides and both parties must return what they had received from each other. It is not applicable in cases where the creditor rescinds the contract executed by his debtor in favor of other persons, because the creditor will not have anything to restore in the first place since he did not receive anything from the debtor. However, rescission will not prosper when the thing had already been legally transferred to a third person, such as by way of sale, and he is in good faith that the transfer to him will be respected. Now for the example of Article 1385, the situation consists: A sold to B a piece of land in fraud of his creditors. B took legal possession, if no other means are found to the exact satisfaction of the credits owning the creditors. Now the question is that, may the sale to B be rescinded? Answer is that it depends upon whether B was in good faith or in bad faith. In the first case, if B was in good faith, rescission cannot take place because the object of the contract is legally in the possession of a third person who did not act in bad faith. The second situation is that if B was in bad faith, rescission is proper. Now for the next article, Article 1391, the action for the annulment shall be brought within 4 years. The interpretation for this article, the action for annulment must be commenced within a period of 4 years. If the action refers to contracts entered by the incapacitated persons, the period shall be counted from the time the guardianship case ceases. If it refers to those where consent is vitiated by violence, intimidation, or undue influence, the period shall be counted from the time such violence, intimidation, or undue influence ceases or disappears. And if it refers to those where consent is vitiated by mistake or fraud, the period shall be counted from the time of the discovery of such mistake or fraud. If the action is not commenced within such period, the right of the party entitled to the institute the action shall prescribe. For the Article 39.1 example, X was the owner of a 10,000 square meter property. X married Y, and out of their union, A, B, and C were born. After the death of Y, X married Z, and they begot as children D, E, and F. After the death of X, the children of the first and the second marriages executed an extrajudicial partition of the forestated property on May 1, 1970. D, E, and F were given 1,000 square meter portion of the property. They were minors at the time of the execution of the document. D was 17 years old, E was 14, and F was 12. And they were made to believe by A, B, and C that unless they sign the document, they will not get any share. Z was not present then. In January 1974, D, E, and F filed an action in court to nullify the suit, alleging they discovered the fraud only in 1973. Now for that example question. Can the minority of D, E, and F be a basis to nullify the partition? The answer is yes. Minority can be a basis to nullify the partition because D, E, and F were not properly represented by their parents or guardians at the time they contracted the extrajudicial partition. Article 39.6 states that the ratification cleanses the contract from all of its defects from the moment it was constituted. The concept of ratification, besides prescription, the action for annulment of a voidable contract may also be extinguished by a ratification. The requisites of the ratification consist of the first, a contract should be tainted with a vice which is susceptible of being cured. Second, the confirmation should be effected by the person who is entitled to do so under the law. Third, it should be effected with knowledge of the vice or defect of the contract. And lastly, fourth, the cause of the nullity or defect should have already disappeared. For the interpretation of this article, the act of ratification cures the defects of the contract, and so it is the same contract had no infirmity from the very beginning. The cleansing of voidable contract retroacts to the time of its constitution. An act for annulment of contract based on its original curable defects can no longer prosper after its due ratification or confirmation, with the exception that the rule of retroactivity shall not prejudice the rights of the innocent third persons, for that will be result in injustice, which is not the intention of the law. In this article example, the situation consists: A, who is a minor, sold his property to B. The sale is voidable due to A's minority. After reaching the age of adulthood, A borrowed money from C. With C's charges of high interest, A ratified the sale he made in favor of B. A's intention was to avoid paying his obligation to C. Now for the question. Can C rescind the sale? The answer is yes. C may rescind the sale made by A when he was still a minor. The retroactive effect of the ratification, which cleanses the voidable contract of its defect from its inception, will not affect or prejudice the rights of C, who is an innocent third person. For the last article that I'll be presenting is the Article 1399. When the defect of the contract consists of the incapacity of one of the parties, the incapacitated person is not obliged to make any restitution except in so far as he has been benefited by the thing or the price received by him. In this article, the time the incapacity ceases and the thing received still exists, the presumption is that he benefited, so that should he ask for the annulment, he must return the same to the other party. If he alienates or squanders the thing instead of annulling, he is deemed to have ratified the contract. It results, therefore, that if he was not benefited, he is not obliged to restore what he had received, but the other contracting party is still bound to return what he had received, whether he has benefited or not. Now from this article example situation, Mrs. S borrowed 20,000 pesos from PG. She and her 14-year-old son, Mario, signed the promissory note for the loan, which the note did not say anything about the capacity of the signers. Mrs. S made the partial payments little by little. After 7 years, she died leaving a balance of 10,000 pesos on the note. PG demanded payment from Mario, who refused to pay. Now from this article situation question, is Mario obligated to pay the remaining balance? The answer is yes. Even if his written contract is voidable due to his minority, Mario isn't absolved from the monetary responsibility, since the Article 1399 comes with the exception that the money Mrs. S borrowed may have also benefited him. And also Mario, after 7 years, comes from the age of adulthood. And that's the end of the presentation. Thank you and have a good day everyone.